You see, This is application number 125, that is Richard Kanukiza Besigye and Haki Besigye.
Thank you, Mr. Your Worship. My name is Vanessa. Here together with the following council for the accused persons. That is only the respondent. We have Amit Mr. Mpanga, the second Jacob, that we now require from Kiza, Martin one. So we don't have to one myself.
For court can pronounce itself on the application for recusal, there is need to determine whether this court has jurisdiction to entertain any application arising from the criminal case where the accused has been committed to high court. Jurisdiction is a creature of statute. A decision by a court without jurisdiction is a nullity. Once accused persons in criminal case number 8 of 2025 were committed to high court on 29th May, this court, having committed the accused persons to high court, does not have jurisdiction to make any decision or order after the committal proceedings. This court can thus not make any decision on the application for recusal because it has no jurisdiction to do so. The committal proceedings in criminal case number 8 having been concluded on 28th May. Accordingly, the accused is further remanded awaiting trial at high court.
Batumalira bumalizi budde era ndowooza omulamuzi yalibadde yakisalawo nakululirwe twasembayo okujja wano kubanga kirabwa n'ayonka n'atali puliida nti komito bw'emala okukolebwa fayiro n'eweerezebwa mu high court ne bagamba nti obujulizi bwonna state emaze obbunoonya buweddeyo n'olw'ensonga eyo musango ogutandika okuwulirwa ate eno waba tewakyali bizinesi. Infact olwali twaba tulina ne kitununa wano olunaku kooti nga 29 lwe yagamba nti buli kimu ekikwatagana n'investigation oba okunoonyereza kiwedde, fayiro eweerezeddwa mu high court, hearing egenda lwe twali tukoma okujja wano bali mu kutuzunza. Dr. Besigye bamuleeta wano, Bedi Lutale naffe batutawaanya. Kati guno mulundi gwakubiri nga tujja wano oluvannyuma lwa komito kyakutuzunziriza, babadde batuzunziriza bwereere. So ekyo kibadde obvious, kibadde kirabwa n'ayonka, era twakibagamba nti tekibangawo mu byafaayo bya Uganda, mu judiciary, mu justice system yaffe nti omuntu amala okukomitingibwa mu high court ate ne tusigala nga tukyajja magistrate court. So ku side yaffe nkitiisize bubi okuba nti tutawaanyiziddwa okuba nga batuleetera, naye mu ngeri endala nti kirina implications nyingi nnyo ku side ya state, era eno blo nene nnyo eri state eno kubanga ebadde mu catch 22 situation ennaku enkaaga ebadde mu catch 22 situation nti ennaku 18 z'olina okukumira omuntu ku remand mu capital offences zaali zaggwako, naye nga zaggwako ng'ate bakyalina obujulizi bwe baagala. Kakati nga balina okuta Dr. Besigye ku mandatory bail, bo kye baali balwanyisa okukola komite ey'amangu nga tebannamalayo obujulizi kwe kuba nti baali bayagala Dr. aleme kufuna bail, no bail, baleme kufuna bail, mandatory bail ejja oluvannyuma lw'emyezi 6. Kakati ne bapapirira ne bagaaka bakole komito, naye ng'ate tebannamala kumaliriza bujulizi, baagala okusumulula amasimu bafune obujulizi, ne baagala to eat their cake and have it, nti bafune komito Dr. Besigye bamutwale mu high court okuwulirizibwa, omusango gutandika okuwulirizibwa, but at the same time basigale era nga bakyanoonyereza ekitaliyo mu mateeka. Kaakati kitegeeza ki? Baafuna komito yaliwo nga 29 omwezi oguwedde, meaning nti Dr. Besigye kati na Bedi Lutale balindwa hearing, naye kye batagenda kufuna bwe bujulizi bwe badde baagala obw'oku opening up amasimu, kubanga kooti yokka yeyina okulagira, ate erina kuba kooti eno eya wansi, eri eya waggulu yeewuliriza musango nga guwedde, obujulizi buwedde okunoonyerezebwa. So high court tewaayo obudde bwagamba nti ate muddeeyo munoonyereze. Kakati kitegeeza nti omusango oguli mu high court ogugenda bwe baweerezaayo for trial tegulina bujulizi, kubanga obujulizi bwe badde baagala buli masimu gano ge boogerako. Kati ate tebagabakkiriza gaggula obujulizi bwe badde baagala tebabufunye, n'olw'ensonga eri buli omusango nagwo si dead completely mufu, kuba tegulina bujulizi. Fayiro baagiweerezaayo nga kiwowongole, temuliimu busomyo, temuliimu bujulizi bwe baagala, tebuliimu. Kooti ebagambye ffe engeri gye twaweereza fayiro mu high court tetukyalina bujulizi, buyinza bubakkiriza genda maaso nakunoonyereza. So tubagamba n'ogwo omusango baguggyeyo bate Dr. Besigye kuba tegukyalina makulu, obujulizi obukulu bwe badde baagala tebuliimu. So nagwo era gwakumala budde. So kye kitegeeza mandatory bail application yaffe ekyaliyo, yadde Dr. Besigye no Bedi Lutale babakomitinga mu high court, tekitegeeza nti kibajjako right yaabwe okufuna gye bayita mandatory bail omuntu ng'awezezza emyezi 6 ng'ali ku remand nga fayiro tenaweerezebwa mu high court. So n'olw'ensonga eyo application yaffe twagala ewulirwe. Baagiwadde Justice Baguma yagenda ogiwuliriza, naye ebyo tugenda bimanaginga. Baate eno fayiro kati eri mu ICD, eri mu International Crimes Division, fayiro eya case, substantive case, naye eya bail ate eri mu Criminal Division wa Justice Baguma. Katugenda kulaba ebyo tubihandolinga, so tugenda tannaba kutuwa lunaku, naye twagala ebyo tulabe we tubimaliriza ebya mandatory bail, kubanga tekijjawo right ya Dr. Besigye ne Bedi Lutale okufuna bail oluvannyuma lw'okubeera nga baamala ennaku ezisukka mu 6 mu 18 ku remand. They have just been wasting our time. Obviously, it's no brainer, and it's obvious that once one has been committed to High Court for trial, you cannot reopen the case for investigation. It's no brainer. Even an ordinary person, a lay person would know this, that the jurisdiction of this honorable court is exhausted at a time when committal proceedings are conducted. In other words, we have a doctrine of functus officio. Once the lower court has exhausted its powers, its jurisdiction, its mandate, it becomes functus officio. In other words, its hands are tied. You have no choice but to terminate the proceedings. So that is the thing. This magistrate had no choice but to terminate all the proceedings relating to Dr. Besigye's case after conducting the committal proceedings on the 29th of May. And this is been actually waste of time. But on the side of the case, in regards to the merits of the matter, the substantive case before the High Court right now, it's a huge blow to the state, in that they wanted this evidence to support their charges. And it's the reason they put in this application, so that court could issue an order to allow them access the data on Dr. Besigye and Obed Mutale's phones, which court has now rejected because they have no jurisdiction. Obviously, as we explained, they had a dilemma. They were in a catch-22 situation. They were placed between a rock and a hard surface. They had 6 months within which to conduct the investigations, which lapsed on the 20th of May. But at that time, by that time rather, they had not exhausted all the investigations. And all they had to do is to admit Dr. Besigye on mandatory bail in accordance with the provisions of Article 23 of the Constitution. Yet they never wanted Dr. Besigye released. So they had to keep him on remand under all circumstances. But their time had run out. They had to close the case at that time. But they still had a pending application to access data, which they had to pursue. And there was no way they could still keep Dr. Besigye on remand after the expiry of the mandatory remand period of 180 days. So that's the catch-22 situation they had to deal with. So they wanted two things. One, to have Dr. Besigye on remand, but at the same time continue investigations even after the mandatory period of remand. They couldn't achieve both. So they had to go with one of the two. Either you have Dr. Besigye released on mandatory remand and continue with investigations until such a time when you are done and ready to proceed with the hearing, or you have Dr. Besigye committed to High Court for trial, and you forget all about the evidence which you wanted to substantiate your case. So that's where they are. So now where we stand today, they cannot have this critical evidence they wanted to support their case. Because now the magistrate has, and rightly so, decided that she has no jurisdiction because she is functus officio. She exhausted that jurisdiction, and therefore they cannot proceed with the application to access Dr. Besigye's information. And that has far-reaching implications on the merits of the matter, because they badly needed this evidence to support the charges before the High Court now. So that's the call we are making now. Now that their case is hollow, they should have it withdrawn. It should be withdrawn, because without this critical evidence, it's an exercise in futility for them to proceed with the prosecution. It's no brainer again to say that they have no case against Dr. Besigye without this kind of evidence, which they badly needed, and they cannot have it. It's a fait accompli now. It's gone, totally gone, because the High Court cannot open even the slightest window of ventilation to allow them smuggle in this evidence. It's not possible. Kaput. So the case is completely kaput. The reason they should release Dr. Besigye. That said, for us, we are proceeding with the application for mandatory bail, which we filed upon the expiry of 180 days on remand. It's now pending before Justice Baguma. Only that we need to deal with the issue of management of the two files. The substantive case is before the ICD. Yet the application for bail is in the criminal division. So we are going to sort that out administratively and have this matter fixed for hearing so that we can have Dr. Besigye and Obedi Ritale released. Thank you.
Omusumba ye n'asaba n'agamba bagawugule gagende wakumuguma 13
naye gavumenti yatumukuzanira ku mitwe
era mbyagalire ddala pulezidenti wange
be twasaba bajje batusabire tebakoze eki tebalabise
tugenda kwekalakasa paka eza paka kulira